Good afternoon, Your Honours. This is case number IT0259S, the prosecutor versus Darko Mrđa.
Thank you, Mr. Registrar. Before I ask the appearances, Mr. Mrđa, could you confirm to me that you can hear me in a language you understand?
Your Honour, yes, I can hear you. Thank you.
Thank you. Please be seated, Mr. Mrđa.
Thank you.
I have the appearances. Prosecution first.
Good afternoon, Mr. President, Your Honors. Alan Teeger and Tim Resch on behalf of the prosecution, assisted by case manager Sky Winner.
Thank you, Mr. Teeger, and for the defense.
Good afternoon, Your Honors. Vojislav Dimitrievich, defense counsel, and my learned colleague Otmar Wachenheim is co-counsel.
Thank you, Mr. Dimitrievich. First of all, good afternoon to everyone in this courtroom and those assisting us just outside of this courtroom. We are sitting today to deliver our sentencing judgment of Darko Mrđa for his participation in the murder of approximately 200 civilians and the inhumane acts through attempted murder of 12 civilians at Goričanske Stijene in Bosnia and Herzegovina on the 21st of August 1992. What now follows is only a summary of the written judgment and does not form part of that. The full text of the judgment will be made available to the prosecution, to the defense counsel, and the public at the close of this session. We'll briefly set out the context and facts of the case before going on to review the factors which we took into consideration in determining sentence. Darko Mrđa was born on the 28th of June 1967 in Zagreb, Croatia. He grew up in Tukovi, in the municipality of Prijedor, in Bosnia and Herzegovina, and worked at the nearby mine in Omaska. In 1992, during the conflict in Bosnia and Herzegovina, he was a member of a special police unit known as the Intervention Squad, serving under the Bosnian Serb authorities in Prijedor. On the 26th of April 2002, Judge Liu confirmed the indictment issued by the prosecution against Mrđa, and it initially charged 3 counts. Extermination as a crime against humanity under count 1, murder as a violation of the laws or customs of war under count 2, and inhumane acts as a crime against humanity under count 3. On the 13th of June 2002, Darko Mrđa was arrested and was subsequently transferred to the detention unit of the tribunal. On the 17th of June 2002, he appeared before the tribunal and entered a plea of not guilty. 1 year later, on the 24th of July 2003, Darko Mrđa entered into a plea agreement with the prosecution. In accordance with the plea agreement, the prosecution withdrew, with the consent of the trial chamber, the charges under count 1 of the indictment. Mrđa admitted responsibility for murder and inhumane acts through attempted murder under counts 2 and 3 of the indictment. He also agreed to cooperate with the prosecution. Thereafter, at the hearing of the 24th of July 2003, Mrđa pleaded guilty to counts 2 and 3. The trial chamber accepted this plea after being satisfied that it had been made voluntarily, that it was informed and unequivocal, and that there was sufficient factual basis for the crimes and for Mrđa's participation in them. What now follows is a summary of the facts which formed the basis of Mrđa's conviction as described in the plea agreement. In August 1992, an armed conflict was underway in Bosnia and Herzegovina. The conflict involved a widespread and systematic attack upon the non-Serb civilian population in the municipality of Prijedor. Mrđa has acknowledged that the crimes to which he has pleaded guilty were part of this widespread and systematic attack. On the 21st of August 1992, Mrđa was a member of the Prijedor intervention squad, which I just referred to. On this day, Mrđa, in his official capacity as a police officer, participated in escorting an organized convoy of Muslim and other non-Serb civilians from Tukovi and the Trnopolje camp in the Prijedor area in the direction of the municipality of Travnik. The convoy consisted of buses and trucks loaded with civilians. At a location on the road along the Jelomska River between Skandervaguf and Mount Vlasic, the convoy stopped. Mrđa and other members of the intervention squad actively implemented orders to separate military-aged men from the rest of the convoy. Mrđa personally selected men from the convoy with the awareness and the expectation that they would be murdered. A large number of men, estimated in excess of 200, were loaded onto 2 buses. Mrđa and the other members of the intervention squad took the separated men in the 2 buses to Korochanske Stijene. The men from one of the buses were ordered off the bus, escorted to the side of the road above a deep ravine, ordered to kneel, and were then shot and killed. The men from the other bus were taken off in smaller groups of 2 or 3 and were then shot and killed. Together with the other members of the intervention squad, Mrđa personally and directly participated in the unloading, guarding, escorting, shooting, and killing of the unarmed men at Korochanske Stijene. Except for 12 men who survived the massacre, all of the men taken from the 2 buses were murdered. We'll now give an overview of the factors we have taken into consideration in assessing the seriousness of the crime. We'll then briefly discuss the aggravating and mitigating circumstances applicable in the present case. Seriousness of the crimes. In determining the seriousness of the crimes, we have given consideration to the scope and general nature of the offences committed, the role played by Darko Mrđa, and the impact of the crime upon the victims and their families. In relation to the scope of the crimes, it has not been possible to determine the precise number of civilians killed by Mrđa himself. However, his participation in a large-scale massacre in which about 200 civilians were killed is uncontested. As for Mrđa's role, he was not the architect of the massacre. Together with other members of the intervention squad, he was acting in furtherance of superior orders. Nevertheless, we conclude that the fact that Mrđa personally participated in the selection of the civilians who were going to be killed and in the subsequent murder and attempted murder of 12 of them, knowing that a widespread and systematic attack against civilians was underway, makes these crimes charged especially serious. Lastly, we evaluated the seriousness of Mrđa's crimes in the light of their impact upon the victims and their effects upon the victims' families. In so doing, we examined the statements of some of those who survived the massacres, which were presented by the prosecution. Further, at the hearing of the 24th of July 2003, we heard two witnesses. Mr. Mojkanovic, a survivor of the crimes, and Ms. Karabasic, the president of the ISFAR Association of Prijedor Women. The significant effect of the crimes upon the victims' families adds to the seriousness of the crimes. As to the impact of the crimes on the victims, we are convinced, beyond a reasonable doubt, that most of them were subjected to a level of suffering which significantly exceeded the level of suffering usually suffered by victims of murders and inhumane acts. We have considered the level of suffering inflicted on the victims as an aggravating factor. We conclude that the sentence should reflect all of the cruelty and inhumanity embodied in Darko Mrđa's direct participation in the shooting of more than 200 civilians, of which all but 12 were killed. Aggravating and mitigating circumstances. In addition to the aforementioned ground of aggravation relating to the impact of the crimes upon victims, we have considered the two aggravating circumstances put forth by the prosecution, namely the vulnerability of the victims and Mrđa's position of authority. With regard to the former, we consider that the fact that the victims were civilians cannot as such be taken into account as an aggravating factor, as it is already an element of murder as a violation of the laws or customs of war and of inhumane acts as a crime against humanity. However, we have found that the fact that a considerable number of victims had previously been detained in camps and were therefore particularly vulnerable should indeed aggravate the sentence. Moreover, we have found that the position of Darko Mrđa as a policeman is an aggravating factor, but we do not attach much weight to that. The trial chamber also examined a total of 7 mitigating circumstances pleaded by the prosecution and the defense, that is, duress and compliance with superior orders, cooperation with the prosecution, the guilty plea itself, Mrđa's remorse, Mrđa's personal circumstances, the length of time which elapsed between the crime and the trial, and the fact that Mrđa must serve his sentence in a country outside the area of the former Yugoslavia, where he used to live with his family. As to the argument of duress, we have found that the defense failed to show that Mrđa would have been killed or would have at least suffered serious consequences had he not carried out the orders of his superiors. We accept that the difficult circumstances prevailing at the time of the crime may have had some influence on the criminal behavior of Mrđa, although we do not accept that those circumstances were such that Mrđa had no alternative but to participate in a massacre of around 200 civilians. The absence of any convincing evidence and any meaningful sign that Darko Mrđa wanted to dissociate himself from the massacre at the time of its commission prevented us from accepting duress as a mitigating circumstance. In making this determination, we fully took into account Mrđa's age and low rank. With respect to adherence to superior orders, a discretionary mitigating factor provided for in Article 7.4 of the statute of the tribunal, we consider that the orders Mrđa acted on were so manifestly unlawful that he must have been well aware that they violated the most elementary laws of war and the basic dictates of humanity. The fact that Mrđa obeyed such orders, as opposed to acting on his own initiative, does not merit mitigation of punishment. In respect of Mrđa's cooperation with the prosecution, we accept the prosecution's submission that it has been significant. This counts as a mitigating circumstance. We also hold that Mrđa's guilty plea helps to establish the truth surrounding the crimes committed at Koročanske Stijene and may contribute to promoting reconciliation between the peoples of Bosnia and Herzegovina. We note incidentally that his plea made it possible to obviate the expense of a lengthy trial and the need for a large number of victims and witnesses to come and testify at the tribunal. We therefore consider the guilty plea to be a mitigating factor. As to remorse, we hold that the expression of Mrđa's remorse is sincere and should be taken into account in mitigation. We find that Mrđa's personal circumstances, in particular the fact that he was raised under difficult circumstances, his good conduct whilst in detention, and the fact that since the events in August 1992 he is married and has 2 children, one of whom is chronically ill, should be considered together in mitigation, but that little weight should be attached to them in this regard. As for the length of time which elapsed between the crimes and the trial, we note that the defense seems to confuse this issue with that of the right to be tried within a reasonable period of time. A violation of that right cannot be sustained here, since the relevant time runs only from the moment an accused is either formally charged by the tribunal or is arrested. Mrđa was indicted on the 26th of April 2002. Was indicted on that date and was arrested on the 13th of June 2002. That is less than 2 years before the hearings commenced. Furthermore, we are of the view that for crimes such as those charged in the present case, of a seriousness justifying their exclusion from statutory limitation, a lapse of time of almost 12 years between commission of the crimes and sentencing proceedings is not so long as to be considered a factor in mitigation. Finally, we recognize that the fact that Mrđa must serve his sentence in a state different from that which his family resides in, and whose language he does not speak, may constitute an additional hardship for him. This factor is to be taken into account when determining the appropriate sentence, but it's not as such a mitigating circumstance. Mr. Mrđa, would you please rise? Mr. Mrđa, we have duly examined the evidence relevant to an accurate determination of the seriousness of the murders, constituting war crimes and inhumane acts, attempted murders, constituting crimes against humanity of which you have been found guilty. The sentence you receive should be proportional to all the seriousness, cruelty, and inhumanity of the massacre, which took the lives of around 200 civilians and inflicted considerable suffering upon the survivors and the victims' families. We consider that the special vulnerability of the victims at the time of the commission of the crime and the particularly high level of suffering you inflicted upon them are aggravating factors. Your position of authority as a policeman was also considered an aggravating factor, but of limited weight. Moreover, we've taken into account most of the mitigating circumstances you raised. You cooperated in a substantial manner with the prosecution. You pleaded guilty, and you have expressed remorse. Your personal and family situation also have been considered. We dismissed, however, your submissions with respect to duress, superior orders, and the time which elapsed since the commission of the crimes. This trial chamber hereby sentences you, Darko Mrđa, to 17 years of imprisonment. You're entitled to credit for time spent in detention, namely 658 days. Please be seated. Where in the summary of the judgment I said that we heard witnesses on the 24th of July 2003, I should stand corrected, since these witnesses were heard during the sentencing hearing which took place in October of that same year. The tribunal stands adjourned.
All rise. Veuillez vous lever.